Good thing. All right. So shortly after midnight yesterday, now this was filed April 19th. So we're talking about April 18th, which is Good Friday. Good Friday, the day that I was sentenced in my case. So here we go. Shortly after midnight yesterday, the court hastily and prematurely granted unprecedented emergency relief. Proceeding under the All Writs Act, 28 U.S.C. 1651, the court ordered the government not to remove a putative class of detainees until this court issues a superseding order. Although the order does not define the putative class, it appears that the court means all members of the class that the habeas petitioners sought to have certified, namely, quote, all non-citizens in custody in the Northern District of Texas who were, are, or will be subject to the March 2025 presidential proclamation entitled Invocation of the Alien Enemies Act regarding the invasion of the United States by Tren de Aragua and or its implementation. That was a fucking mouthful, but it's a specific group of detainees who are set to be deported under this Alien Enemies Act, which is an 1800s act that has been around and is still purportedly good law. So this is the citation is to a motion for class certification in number 125 CV59 in the Northern District of Texas, et cetera, et cetera, et cetera. So we'll get to what that means, but they're making a class, or they're motioning for class certification for a class action lawsuit so that all of them can be represented together as they are all similarly situated, they're alleging that they are similarly situated, sufficient to certify them as a class. The government would want to oppose this. They would want each of these individuals to have to fight individually rather than as that class. And what they would want to do to prevent certification is to show that there are significant and sufficient differences between each of the individual members to prevent them from being legally similarly situated. And what they'll say is each one of their situations is unique. And when we're talking about gang members, MS-13 gang members, for example, when you're talking about that, oh, that's a better look, I think. Maybe not. But when you're talking about MS-13 gang members and deportation, it can kind of go both ways. Just because you're in a gang from the same country doesn't mean that you have the same arguments against deportation. Your arguments against deportation as an illegal immigrant tend to come down to questions of amnesty. Is there some reason that the U.S. must grant you basically humane reasons to remain in the country? In this case, this is a Venezuelan gang, I believe. And their argument is that a return to Venezuela or deportation to El Salvador in a temporary measure subjects them to treatment based on politics or some other classification at the hands of government that puts them at serious risk of inhumanity, for lack of a better word, that they would be tortured, that they would be treated outside of the bounds of human decency. And therefore, they should be granted amnesty and allowed to stay in the United States, would be the argument. The problem is, do all of these guys face that in the same way? And I have no idea. Like, if you're in MS-13 in Venezuela, are you going to automatically be treated in a way that is inhumane or in violation of international law or anything like that? I don't know. If they're all treated the same, then sure. Why are you not looking into the camera? Because I'm looking at my screen with my document on it. The camera's right there. Hey, how you guys doing? It helps me. It helps me to look at the screen. But I can look here if you'd like. The question is, are they equally at risk or sufficiently equally at risk to be certified as a class, to be treated the same? And the government's argument is going to be no. Each of these guys has different concerns. They have different crimes. Just because they're in the same gang doesn't mean they're all subject to the same treatment. And each one should assert their reasons for being granted amnesty protection in the United States individually rather than as a group. And I gotta agree for the most part when it comes to government treatment of a gang. I don't think class certification is appropriate. But maybe it is. But it seems like a criminal enterprise in a foreign country just because they'll be punished harshly. And I don't want anybody to be punished inhumanely, I guess. I don't really care. Like, let's not make too much about it. I don't have a lot of sympathy for the plight of a Venezuelan gang, but generally we want legal systems to treat people in a humane manner. But hey, if Venezuela is going to treat them as criminals because they commit a bunch of crimes, it's going to be hard to argue that even qualifies for amnesty in the first place. Now, if the labeling of these particular members as a gang is improper, like let's say this isn't true, but let's say they all worked for the Peace Corps, but Venezuela just decides that they're MS-13 members and they create a gang label for them with a false criminal RICO style allegation, and then start treating them poorly. But that's just an obvious government cover. That's what amnesty would be for, right? Or when you see genocides of ethnic groups or of political groups that are then labeled as gangs or criminal elements or terrorist cells when they're not. That's what these types of protections exist for in international law. But I'm not aware of that going on. Maybe it is. But each one of these guys will the government will want them to argue individually. They don't want them to argue as a class. And if they argue as a class, who else gets to join the class? How big does it get to be? Because if this putative class is granted class status, then every single group of people who are subject to deportation are going to follow suit. Like if they can find enough to band together. And more importantly, they're utilizing the government's classification of them as a dangerous gang to then establish them as similarly situated. And I still disagree. Not all gang members are equally culpable or equally criminal, and therefore they're not all equally at risk. Unless they are, again, I'm not an expert on Venezuelan treatment of these guys. I don't really give a shit. I hope that's bad. Cup is as big as your head or nose. It is large. It's a large cup. Holds a lot of tea. All right, here we go. I like
grounds. What a business.
What a business. I should probably get some Taylor business voices. What do we got? What do we got? Oh, wait, let's get back to this. So anyway, they're trying to get the class certified, long story short. And although the court does not specify what it means by the government, it appears that the term is intended to embrace all the named defendants, including the president. With the Federal Rules of Civil Procedure 65D2, that's for class certification. So then we have a footnote. It appears that the applicants have recently moved to amend their class petition for habeas corpus and their motion for class certification. It is not clear if the applicants will continue to defend this specific definition or will argue for a new one. So again, all of this is happening very quickly, and Alito's going to lay it out. Have you tried extra spicy chai tea? I'm not a big chai tea person. I'm really not. The court did all this even though. Now, this is where Alito gets serious. Alito is serious because he has dropped bullet points. And these bullet points are actually really devastating. And they go through some legal points and constitutional concepts that are pretty important. Okay, so here's back to Alito. He says the court did all this even though it is not clear that the court has jurisdiction. And this is a critical question here because the Supreme Court's jurisdiction is laid out in the Constitution. It has original jurisdiction on certain issues, and it has appellate jurisdiction on but it also is subject to limits by Congress, and Congress can grant the Supreme Court jurisdiction as well. It is not clear that the court had jurisdiction. The All Writs Act does not provide an independent grant of jurisdiction. So the Supreme Court uses the All Writs Act to say, well, basically they have the ability to enforce writs from writs, orders, whatever. They have the ability to enforce them. Again, necessary or appropriate in aid of a court's jurisdiction, et cetera, et cetera, et cetera. But here we go. But Alito is saying the All Writs Act does not provide an independent grant of jurisdiction. So 28 USC 1651 permitting writs necessary or appropriate in aid of a court's jurisdiction. So it permits the court to make writs so long as it's again in aid of an exercise of the court's jurisdiction, but they have to have jurisdiction to be able to grant a writ. They can't just make jurisdiction because they want to make a writ. I hope that makes sense. They can't just grant themselves jurisdiction. They have to have it already. And that's Clinton versus Goldsmith. The express terms of the All Writs Act, quote, confine the power of a court to issuing process in aid of its existing statutory jurisdiction. The act does not enlarge that jurisdiction. Therefore, this court had jurisdiction only if the Court of Appeals had jurisdiction of the applicant's appeal. And this is where things get really messy. See Section 1254, granting this court jurisdiction to review cases in the Courts of Appeals. And the Court of Appeals had jurisdiction only if the supposed order that the applicants appealed amounted to the denial of a preliminary injunction. So that's see Section 1292A1. But here, the order that applicants appealed was what they viewed as the district court's constructive denial of their request for a temporary restraining order. So what happened here is they say that they requested relief from the court and the court did not act in a reasonable time. So it was a constructive denial. Now we're going to get to the details of that in a second. But the court didn't actually issue a ruling in this case, which is where the jurisdiction question comes into play. Because if the court didn't issue a denial, they can't appeal it to the Fifth Circuit. The Fifth Circuit wouldn't have jurisdiction. It would still remain with the district court. Lots of lawyers really want the district court to rule on their case, and they can't just run to the appeals court and say, we're appealing it because the district court hasn't ruled, therefore it's constructively denied. That's not a thing. They kind of just made an end run here. And the weird thing is the Fifth Circuit kind of took up the question, but that means that it's still a question. So the district court's constructive denial of their request for a temporary restraining order. That is, the district court did not actually deny their most recent request for a TRO, but they inferred that it was constructively denied because the district court failed to rule on that request before the expiration of a truncated counsel-imposed deadline. So the filing lawyers told the court how fast the court needed to issue the order, which we'll have in just a second. The denial of a true temporary restraining order is not appealable. And here, it is not clear that the applicant's TRO request was actually denied. Indeed, in an order issued last night, the Fifth Circuit held that it lacked jurisdiction for this reason. So the next bullet point. It is questionable whether the applicants complied with the general obligation to seek emergency injunctive relief in the district court before seeking or asking for such relief from the appellate court. When the applicants requested such relief in the district court, they insisted on a ruling within 45 minutes on Good Friday. And that is what he was talking about in the previous paragraph. It was a truncated counsel-imposed restriction. Can you imagine a lawyer filing in court and saying, court, you have 45 fucking minutes on Good Friday. You have 45 minutes to make this ruling. In the afternoon even, When the district court did not act within 133 minutes, they filed a notice of appeal, which the district court held deprived it of jurisdiction. So the district court says, okay, well, it's out of our hands. And it goes up to the Court of Appeals. However, that ruling may not be correct at all. The district court doesn't necessarily lose jurisdiction by not ruling, like it on this non-rule based timeline. So it is doubtful that this aborted effort satisfied Federal Rule of Appellate Procedure 8A1C. So just because the district court finds that it doesn't have jurisdiction and now it goes up to the appellate court has to determine if it has jurisdiction, because there's a jurisdictional question. And if they determine that they don't, because the district court didn't actually issue a denial that would then, so it's not appealable yet, then they'll just return jurisdiction back to the district court. Actually, they'll return it down and order the district court to retake jurisdiction over the case. So we still don't know if the appellate court is even supposed to be hearing this. And if the appellate court isn't hearing it, then the Supreme Court can't. When this court rushed to enter its order, the Court of Appeals was considering the issue of emergency relief, and we were informed that a decision would be forthcoming. This court, however, refused to wait, but under this court's Rule 23.3, quote, except in the most extraordinary circumstances, an application for a stay will not be entertained unless the relief requested was first sought in the appropriate court or courts below, or from a judge or judges thereof. So again, the court has a rule that says only an extraordinary circumstance case, the most extraordinary circumstance case. The deportation of gang members is not the most extraordinary case, especially when they're not being deported back to their home country. They're being deported to an intermediary country, El Salvador. I don't want to be deported to an El Salvador prison. Let's be very clear. Doesn't sound like a great place. Don't think they want to be there, but that's just too fucking bad. You violated United States law by entering illegally. If you want to do that and have the justification, you can make an amnesty petition. You can do that. But if you lose, you got to go. You got to go. And their basis for amnesty doesn't seem strong to me. Typically, the punishment for criminal activity is not sufficient justification, even if the punishment is harsh. So long as the punishment is within the country's, the home country's law and within conventional international understanding of humane treatment of people incarcerated. We allow in this world some really fucking bad prison conditions. And just because they don't want to be in prison in Venezuela or El Salvador doesn't mean that they're beyond the pale of international law. Like, there's some really shitty prisons all over the world that are perfectly quote unquote legal. You wouldn't want to go to them. They wouldn't be legal in the United States, but that doesn't matter. That's not how amnesty works. Okay, so here we go. The only papers before this court were those submitted by the applicants. So that's the other thing. The government hasn't even responded yet. The court had not ordered or received a response by the government regarding either the applicant's factual allegations or any of the legal issues presented by the application. And the court did not have the benefit of a government response filed in any of the lower courts either. When the applicants first raised their allegations in the district court, that court provided the government with 24 hours to respond and was poised to rule expeditiously. But the district court dissolved the government's obligation to respond after counsel for applicants filed their hasty appeal, which in the district court's view deprived it of jurisdiction to rule. So translation of that, when they said, hey, we want a ruling within 45 minutes, the district court said the government gets 24 hours to respond. Very fast, by the way. Being forced to respond to something like this, which is a complex issue, within 24 hours is already a very fast timeline. And we're talking about they'd be responding on Holy Saturday, right? Good Friday is when all this is happening. The court's saying, no, respond on Holy Saturday. This is a this is a holiday week, a sacred week for many of the people involved. But the court says, no, this is it. But then once they filed their appeal, district court says, fine, government doesn't have to respond. Fuck you guys. Because we don't have jurisdiction, so it doesn't matter what their response is. So he goes on, the papers before us, while alleging that the applicants were in imminent danger of removal, provided little concrete support for that allegation. So again, they're saying they're in imminent danger of removal, but where's the evidence that the Trump administration is going to remove them within 24 hours, for example? Because that's the timeline that they're actually on in court, is this 24-hour timeline for response. So they're going to be removed before that. Are they going to be removed between mid-afternoon on Good Friday and mid-afternoon on Holy Saturday? We don't know. Members of this court have repeatedly insisted that an All Writs Act injunction pending appeal may only be granted when, among other things, quote, the legal rights at issue are indisputably clear, and even then sparingly, and only in the most critical and exigent circumstances. Again, being deported because you entered the country illegally, and you're being deported as a criminal gang member back to your home country, or actually to an intermediary country where you could presumably be retrieved before being sent all the way home, doesn't come out to be the most critical and exigent circumstances in my mind. And the legal issues are not indisputably clear, because the government can easily raise arguments that these guys are not certifiable as a class. They can actually raise an argument that class certification in this case is impossible, because unless each one is charged with the exact same criminal activity, then their class certification almost necessarily cannot occur. If one guy's charged as an assault and the other guy's as a murder, presumably their punishments are going to be distinctly different. Now, maybe not. And if their punishment is going to be the same, regardless of their criminal history or alleged criminal activity, then you're probably closer towards class certification. But I find that unlikely, even though they're going to get treated harshly, it seems like. That doesn't mean that every one of their crimes are going to be identical or identically treated. And if there's a difference in how they're going to be treated, then they can't be a class. So here we go. What do we got? So this is, the most critical and exigent circumstances. So this is from South Bay United Pentecostal Church versus Newsom. Roberts concurring in denial of application for injunctive relief at that time. Then we've got, see also Hobby Lobby stores versus Sebelius, Lux versus Rodriguez. So again, this emergency injunctive relief is really rare, and that's what these citations are for, according to Alito. Although the court did not hear directly from the government regarding any planned deportations under the Alien Enemies Act in this matter, an attorney representing the government in a different matter informed the district court that in that case, during a hearing yesterday evening, that no such deportations were then planned to occur either yesterday, April 18th, or today, April 19th. So again, not only are they not showing that the government is going to make these deportations prior to the government responding in 24 hours, but in a different case, the government has asserted that there are no planned deportations. The way it's worded here is a little bit unclear, but I assume what Alito is saying is that when the government says, the government in the other case says there are no planned deportations, they mean that there are no planned deportations, not in that case, but none are going to happen in the next 24 hours under the Alien Enemies Act. So even though that's a different group of people, that there's still no plan to do that. So it would, again, give the government time to respond, give the court time to actually contemplate the legal issues and make its ruling. Although the court provided class-wide relief, the district court never certified a class, and this court has never held that class relief may be sought in a habeas proceeding. So that's another thing. This is a novel legal issue in the United States. You have a habeas corpus proceeding. So habeas corpus proceeding says that the detention that they're under is unduly burdensome, unlawful, and therefore unlawful, and not justified under law. So they need to be released or granted relief from a government action. In this case, deportation. So, what he's saying is that this court has never actually held that can be a class action, because again, are there circumstances so similar that dealing with them individually would be pointless, and that dealing with them collectively will produce, or dealing with them individually would be the exact same outcome basically as dealing with them collectively. So then that's why you would certify a class. You make it more efficient and convenient, but they have to be so similarly situated that they're going to get the same result. Not that they would get different results if they were individually dealt with. Again, given the same legal arguments. I mean, obviously, in a practical application, you can have people who are similarly or situated the exact same and have different outcomes because you have different legal arguments being made. Maybe a lawyer misses something, etc. That's the practical versus the actual legal analysis. So in sum, this is a critical paragraph here from Alito. Literally in the middle of the night, the court issued unprecedented and legally questionable relief without giving the lower courts a chance to rule, without hearing from the opposing party, within 8 hours of receiving the application, with dubious factual support for its order, and without providing any explanation for its order. I refused to join the court's order because we had no good reason to think that under the circumstances, issuing an order at midnight was necessary or appropriate. Both the executive and the judiciary have an obligation to follow the law. The executive must proceed under the terms of our orders in Trump versus JGG, and this court should follow established procedures. Okay, so that is Alito's opinion.